Good morning. Happy Tuesday. Leonard French started talking about the First Amendment today. Leonard French, for those of you who don't know, is a copyright attorney. He has the YouTube channel Lawful Masses. I like his channel. You should check it out. He talks a lot of fun legal stuff, and while I don't always agree with him on the politics, I enjoy the discussion that he has in the law. And he seems like a nice guy, and he wears fun hats. And I mean, what more could? And he has dogs. What more could you want? But anyway, he was talking about today about a letter that Trump's attorney sent to CNN, basically a demand letter saying that a poll that CNN had done and then published the results of was biased and defamatory to the president, and that if CNN didn't publish a retraction, then Trump would sue for defamation specifically. And Leonard French came to the same conclusion that I did, that Trump's team would almost certainly lose in ridiculous fashion. And we both agree that actual malice is required. You got the plaintiff would have to show that the defendant acted with actual malice. But where we disagree is that Mr. French believes that the plaintiff would have to show that the defendant was trying to hurt him or hurt his feelings or damage his reputation, etc. And that is not the actual definition of actual malice. Believe it or not, the term actual malice was defined in New York Times v. Sullivan, the landmark case. And in it, the actual malice is defined as publishing defamatory material, knowing it to be false, or with reckless disregard as to whether or not it is true or false. And that reckless disregard is basically where the publisher should have known. If they were doing their job right, there were things that should have indicated to them. A reasonable person would have had serious doubts as to whether or not they should publish it, etc. Obviously, you're going to get into a huge fact-based analysis there, but it's the publishing knowing that it's false or with reckless disregard as to the truth or falsity that is important. That is what the actual malice standard is, and Mr. French did not say it correctly. Now, do I care? Not really. I have been accused of being scared to call out attorneys because attorneys are going to be able to debate me better or something, even though on a daily basis I am literally debating with attorneys as part of my job, be it on paper or in the court. So it's not really a big deal to me, but here you go. Now I have stated that Leonard French was wrong for the whole wide world. You can go ahead and pester him about it, or if he's anything like Matthew Christensen, he'll Google his own name and find me there. Anyway, and just so that we're clear, again, I have no ill will towards Mr. French. I think he's probably a very fine attorney. I know he's done a few cases that are kind of big for the YouTube community. I don't remember exactly what they were. Video game, I think, stuff. Anyway, not saying anything bad about him, but he seemed like he was talking about the common law actual malice standard and not the actual malice standard from New York Times, which relates to public officials. Anyway, thanks for watching. Have a great day.